Thank you, the President, Your Honors. What has been requested by the Defense Counsel for the release of the accused? We, the co-prosecutors, also have seen the Article 82 of the accused right to make such a request. The co-prosecutors wish to state that this is not a new issue. The request for the release on bail has been raised by the defense counsels since during the investigative phase. Therefore, the co-prosecutors consider this request has been rejected by the co-investigating judges. At the same time, there was an appeal to the pre-trial chamber, and the decision of the co-investigating judges, and the pre-trial chamber made a decision to uphold the provisional detention of the accused. That is the historical backgrounds regarding the request raised by the defense counsel of the accused. We, the co-prosecutors, still maintain our positions to request to the pre-trial chamber to continue the detention of this accused with certain reasons as following. 1. The co-prosecutors consider that Rule 63.3 of the internal rules until this time it is still a necessity, because this rule stipulates that if it is to be believed that the accused has been committed the crimes, and at this time the accused himself acknowledges the crimes occurred at S21 in the name of the chairman of that S21. So he acknowledges his responsibility at that office. 2. The co-prosecutors consider that in regards to the request of the detention of the accused at the military court from the 10th of May 1999, we would like to ask whether we, the extraordinary chambers in the courts of Cambodia, has to be responsible for that detention. The co-prosecutors would like to submit that the ECCC is an institution which is independent, separate from the military court, and this chamber has not been in function or in operations in relations to or in agreement with the military court, which is a local court. And these extraordinary chambers in the courts of Cambodia has never requested to the military court to make such detention. Therefore, these extraordinary chambers in the courts of Cambodia is a hybrid tribunal. And these extraordinary chambers in the courts of Cambodia is also an independent institution separate from the national courts or the military court which detained the accused in the past. The extraordinary chambers in the courts of Cambodia, with its independent, is again separate from the military court. These extraordinary chambers in the courts of Cambodia is an internationalized court. And I would like to raise the specific features of these extraordinary chambers. These extraordinary chambers in the courts of Cambodia was established with the agreement between the royal government of Cambodia and the United Nations to create a special law with its own responsibility from its establishment. These extraordinary chambers in the courts of Cambodia is not bound to judge on the appeal of the National Court, and the detention raised by the Defense Counsel is involved the National Court. Therefore, the co-prosecutors consider that if the Defense Counsels at the International Court consider that their client's detention, the competency of the court or of the appeal court is falls within the local appeals court. So we, the co-prosecutors, know that Mr. Kasavot, who has been the defense lawyer for this accused, has the right to make an appeal to the National Court. But his relinquishment of such right is his own responsibility. These extraordinary chambers, in agreement, does not have any agreement with the military court. And the military court also stated the law on the establishment of the ECCC for the charges of the accused. However, I would like to submit that we need to consider the proper proceedings within the chambers, considering the functioning of the office of the co-prosecutors, as well as the functioning of the office of the co-investigating judges. These two offices have their own separate independent duties, and these two offices, which composed of both national and international staff, national and international prosecutors, and national and international investigating judges. So our unique feature is separate from the National Court. Even if you look at the appointment of the judges, they consist of both national and international judges, and they are not related to the National Court. The National Court, this chamber is not responsible for the functioning of the local court or the military court. So the violation of the accused right by the National Court is not the jurisdiction or the responsibility of the chambers. So Duch detention at the military court cannot be taken into account, and for this chamber to make a decision on such issue. Point number 3 that I would like to raise regarding the continuation of the provisional detention is that what the pretrial chamber has decided to uphold the order of the investigating judges and to continue the provisional detention of the accused. We have observed that since that decision of the pretrial chamber until today, we have not seen any changes in circumstances besides the decision of that pretrial chamber. Therefore, even if Article 82.3, which allows the defense counsel to raise such a request, that is his right, either verbally or in writing. However, it needs to be considered that whether the circumstances have changed during the rejection of that appeal or any new circumstances arrived that needs to be considered in order to release him on bail. Point number 4. The co-prosecutors still maintained the provisional detention at this time is necessary to ensure by law, as stipulated in Article 35 on the law on the establishment of the ECCC, which clearly stipulates the prosecution of the accused is only before the trial chamber. Therefore, our submission and the continuation of the provisional detention is to avoid the trial in absentia of the accused. And in order to ensure that, we need the trial chamber to continue the provisional detention to ensure his trial in person. Number 5, in order to ensure the safety and the security of the accused. Duch, until this time, the public, who are the families, members of the victims as the victims themselves, know Duch clearly. Therefore, if the trial chamber releases him on bail, it's going to be an issue which is a risk, and the victims or the victims' families who are angry because their family members suffered or lost their lives during the democratic Cambodia, that would make them angry and take revenge on him. This is an issue on his own safety and security. Moreover, if such revenge occurred on the accused, it will also have an impact on the public order if there is such an attack on the accused. Now the point that I would like to raise is in response to the order raised by the defense councils. It's the order by the military court on the detention. My observation is that it clearly states the military court relinquishes its jurisdiction. So, after the ECCC has been established with its jurisdiction, it means the military court relinquishes its jurisdiction after the establishment of the ECCC, which was in 2006. And the military court already relinquished its jurisdiction after the establishment of the ECCC. So this is clearly stated, and in this order, there is a signature dated the 21st of July 2008. So this decision on the detention, on the relinquishment of the jurisdiction is appropriate, and the co-prosecutors agreed upon the content of the order made by the military court. Because of these reasons, the co-prosecutors still maintained our positions to seek permissions from the trial chamber to continue the provisional detention of this accused. And the last point raised by the defense counsel regarding the deductions of the sentence, etc., and etc., is the discretion of the trial chamber. Thank you.
Monsieur le Président, je vois les parties.
Mr. President, says Mr. Hu, I see the civil parties are on their feet. I'd just like to recall the law. The defense's request to make presentation is within the ambit of Rule 82, in particular paragraph 2, which says at any time the chamber can order the release of an accused or the bail if necessary, or order the accused detention in accordance with these internal rules. The chamber shall so decide after hearing the co-prosecutors, the accused, and his or her lawyers. As I said, the civil parties do not have a role to play in such a discussion.
Civil Parties Group 1, we are aware of Rule 82, paragraph 3. However, because it is such a fundamental issue issue for the civil parties, we would request, Mr. President, to use your discretion to allow at least a few minutes for the lawyers for civil parties to address this court.
Please, lawyer group 1, you take the floor first. Say the President. The President, could the lawyers please wait a moment? We need to discuss a little bit. The President. The civil party lawyer, what would you wish to state at this moment?
Your Honor, we would like to address the Chamber a few minutes about the legality. And a lot has been said about the legality of this request, and we would like to have the opportunity, a few minutes, to address the Chamber on the legality of this request. Did you get what I said? Thank you, Your Honor.
parle tous là-dessus.
President, just now the civil party lawyer tried to make some observation concerning the legality, but this legality matter has been raised by the Defense Council, but latest matter here is about the comments made by the Defense Council concerning the release on bail of their client, so that his client can be kept in a more separate secured building. And in Rule 82.2 and Rule subparagraph 3 of the same rule, in the decision to decide on the matter, the trial chamber lists or hear only the defense counsel, the accused, and the co-prosecutors, and that the trial chamber will not listen to the civil parties. So we will make sure that sub-rule number 2 and sub-rule 3 of Rule 82 are genuinely abided. So the trial chamber who will speak first, says the President. What are the other issues you would like to raise?
Could I request, or could we request to reconsider your decision that you have taken and recall the decision from 20th of March 2008 of the pretrial chamber? This decision was on civil parties' rights concerning the question if civil parties are allowed to participate, and not only physically, but to participate in detention appeal hearings. And this pretrial chamber decisions outlined the extent of civil party participation. And I would like to recall that, of course, this court should also be consistent, even if this decision, fundamental decision on civil parties' rights, was taken by the pretrial chamber in the case against Nguyen Chia. And I would like to let you know the pretrial chamber, or what the reasons were why the pretrial chamber decided that civil parties and their interests are concerned if the accused appeals the detention order, and if it is pending, if maybe the accused could be released. The pretrial chamber stated that civil parties' rights, and namely the right to reparation and to seek reparations, could be affected, and therefore civil parties should perform their rights before, and this is only an example of course, but before the pretrial chamber during the hearing. That means also we were allowed and could submit written pleadings and to give short oral observations in the hearing itself. And we have here, if I compare the situation in the pretrial phase with the request now of the defense asking for the release of the accused, which is comparable from the content, even if we are now at the trial stage, with the situation when the defense or the accused, the charged person, appealed the detention order, or are appealing now in case 2 the extension of the detention order. And I think the trial chamber should reconsider its decision according to Rule 82 and to take into account that, of course, only the reason that civil parties or civil party lawyers, co-lawyers, are not mentioned in Rule 82, 2 and 3 does not mean automatically, if you have a look on the idea and the spirit of civil party participation, and to look first, we are parties and not anybody or nothing. Secondly, civil parties are directly concerned with possible or the decision the chamber may take upon the request of the defense. And of course, therefore, civil parties have, or their views and concerns have to be taken into account, and again, the fundamental, or one of the fundamental rights of participation is the right to be heard. And this is something, and moreover, if it is a matter that concerns civil parties directly, so that I please the chamber to reconsider its decision from today to reject that civil parties could take a position, or again to review and have a consistent jurisprudence within this court and in the whole of this court, even if not you have taken this decision from, which I mentioned, the fundamental decision from 20th of March 2008. But I think for civil parties it is the same matter that is concerned, and so of course the trial chamber should not take another position and excluding with a formal argument civil parties are not mentioned in Rule 82, 2 and 3, and this is a formal argument, but
the President, the trial chamber already note the request, and I think it will take the whole day to hear that argument. The trial chamber will take this matter to be considered at within the day. Would you like to add any further or make any further comments?
I do not know, sorry, I do not know when the mic was cut off and what was possible to be translated, because I didn't see it, and therefore I would like to get guidance.
The President, now the trial chamber would like to inform you that the chamber will take your request to be considered during lunch break, and after the break then we will make a decision on the rights of the civil parties in regard to the request, the argument made by the defense counsel for the release on bail of their client, and also we need to discuss the matter in conjunction with the existing sub-rule 2.3 of Rule 82. Are you clear?
Okay. Mr. President, Your Honor, first I would like to clarify which parts of my speech could be heard and could be translated. I didn't observe when the mic was cut off. Okay. And then, secondly, I would like to get guidance, or if you also take into account, as far as I understand, you want to decide the request of the defense, but I think first you should decide on the request for reconsideration, taking into account the pre-trial chamber jurisprudence. And no, c'était pas ça. Okay.
Ms. Jacquin, if I may make a few points for Civil Party Group 3, I am Martin Jacquin. The defense immediately referred to Article 82, asking that the Chamber consider its application without hearing the civil parties. This is unconscionable for the civil parties because Mr. Duch's application for release is surreal in these circumstances. So we have recalled Article 82, which has been invoked for the first time before you, because this is the first time that such an application for release has been brought before a trial chamber. You can hear any party that you so wish. I think that the civil parties have the right to ask for the floor. I recall very quickly that Mr. Duch expressed remorse and regret and request for forgiveness. And the day after that, he applies for release based on a number of arguments, of legal arguments, seeking to rely on compliance with the law in his argument. He talks about fairness, and I think that there is a minimum of recognition of the suffering of civil parties which is due here. In that light, Mr. Duch's application is unconscionable. So how can he say that he is remorseful when he asks for forgiveness and the next day asks for release? I insisted this morning that we should read out the factual analysis one by one as accepted by Mr. Duch. I think it is important for Mr. Duch to realize the gravity of the events that have brought him here today. And these facts are of particular moment to the civil parties who loved their loved ones and whose lives were destroyed. We should bear in mind that the 100 or so civil parties that I represent are brave people in light of the difficulties they have encountered since the end of the Khmer Rouge regime. These are my submissions. Thank you. Mr. Sur.
The President, I would advise you that not to repeat the same arguments. Thanks.
Things I shall say in 2 minutes. First, during the pre-trial hearing on 18th February last, I said that as far as I was concerned, the civil parties should not take part in proceedings pertaining to the sentence. However, it is necessary and indispensable for us to respond to the arguments put forward by the defense in the issue of the provisional detention, as is the case under French law, which underpins the hybrid court before which we are today. Secondly, the civil parties are present in the proceedings on detention in the cases that will be brought before you for trial. So how can it then be possible that the civil party would have less rights in a public hearing than in hearings that arise from the investigation? it is not legally possible, and it is difficult for our clients to understand. Thirdly, in pure law, Mr. President, we have Article 82, but we also have Article 63. It is the self-same thing, but it applies to the investigation phase. And there you have reference to civil parties. Reference is made to Article 63 and 82. Therefore, it follows that these articles should be read together in light of the existence of the civil party both in investigative proceedings and at trial. That is why we should and we can, and that is why it is necessary for us to address the court on this important issue, that is the appearance in freedom of Duch, or whether he is detained.
The President, we have already informed the parties that your request will be noted, and as I informed you already that the discussion will be based on the sub-rule 2 and 3 of Rule 82, and the Chamber notes these requests and will have them discussed during lunch break. When we resume our session, then we will announce the decision regarding the matter. So it is time to break for lunch. So the Chamber would like to adjourn for the lunch break, and we resume at 1:30. The detention facility guard, please take the accused back to the detention facility and bring him back before 1:30.